Good morning to everyone. My warm regards to all my viewers. I am Advocate Aditya Rana, and today we are here to discuss about the relevance of a legal notice. We are here. The broader perspective would be revolving around what a legal notice is, how is it to be drafted, what is the relevance, what is the importance of a legal notice in our litigation. So, the first and foremost thing that comes into the mind while dealing with the subject term, that is legal notice, it comes that there's a pivot role of legal drafting, which is the main essence of a good, established, well knit legal notice, which will help you in the long run. We, as an advocate, have a very big responsibility for keeping each and every aspect in mind while drafting a legal notice, because everything, every fact and matter needs to be included, keeping in mind what will be the outcome of this if the matter goes into a litigation stage. Because legal notices, they're generally a pre-litigation stage things. So now, here we may say drafting may be defined as the synthesis of law and fact in a language form. Legal notice does not say that you need to specifically stick to a single language. You can use any language, any local language understand it between the which is understood by the parties, but there should be a synthesis of law while you are dealing with the legal notice. So now we generally see that people enter into so many agreements or contracts as individuals or entities in today's society. So the legal notice has become a standard medium for resolving issues between the parties. First step wherein the issue originates and one party claims its right from other. It comes from a legal notice. How does the other party, how does a party with whom there's a dispute come to this conclusion that what are the grudges that is being raised by the sender of a legal notice? So legal notice plays a key role in making the things clear. In fact, in India, the vast majority of legal proceedings begin with filing of a legal notice. In reality, if handled correctly and swiftly, lawsuits can be avoided, because if you are very clear about what the law says, what the interpretation is, and what the remedy is, and you are able to transmit it to the other person, the addressee or the person who the noticee, whom it has been addressed, the other person will easily understand, okay, what will this particular dispute lead to. So many litigations may be decided at a very pre-litigation stage, following the route of mediation, conciliations, or negotiations based on how well a legal notice is. So out of court settlements, they are also based on the fact and material of a legal notice. If the legal notice is vague, it's not able to communicate the actual essence of the dispute, then it's of no use. Litigations, rounds of litigations will be there. Now, today here we will try to understand the concept, procedure, and significance of submitting a legal notice. What is this legal notice? How is it important? What is the concept? What is the procedure behind this? And every other thing. So, giving a gist about this is, in some cases, legal notice is a mandatory thing, such as if we are dealing with the check bouncing cases, NIH. Sending a legal notice is a mandatory thing, whereas in some other cases, it's an obligatory thing, where we seek remedy outside the court, saying, okay, we are desired, if you will not adhere to this, we'll go further, we'll try this in legal remedies, we'll try this in a court of law as per the law of land, and we are eager to settle it if the other party is willing. So, all those things. Now, let's understand what is the basic or legal notice. What basically a legal notice means in a very common sense. Legal notices are generally sent in civil cases. As in criminal cases, legal notices are not sent as their one party is central government or state, and the person involved in an offense is not sent a legal notice. He is summoned because an FIR is lost. So legal notice in criminal cases, except in NIA, that's a special provision. So legal notices are generally sent in a civil case. It's a mode of communication sent by one party to another, either as an individual or as a corporation, with the goal of initiating legal actions against them. There are two parties, one is the sender, one is the receiver, or you can say sender, noticee, addressee. These are broadly the parties or parties to a legal notice. It's a communication. Basically, it's a communication saying that we will initiate a legal action against you because there is a breach of some terms or conditions, or there is a legal right which has been infringed by you. So we are claiming our rights. So in case you do not adhere to fulfilling our requirements or requests, we will be compelled to follow the course of law. So, as I said, it's a pre-litigation stage wherein to avoid further legal repercussions, parties to a dispute grant an opportunity to both to them for an amicable settlement. As I told you, there are broadly two parties. One is sender, one is addressee. We term them as a noticee also. What now sender seeks from this? It seeks to inform the sender. It seeks to inform the other party that they must amend their conduct or address their disagreement with a certain time frame. In a legal notice, it's never kept as an open ended. Like the person who is sending a notice gives a time frame that from date of receipt within 15 days you need to do this, or you need to amend your conduct or address the disagreements, saying that if you do not stop from doing this, or if you do not grant us our claims, if you do not adhere to the contractual obligations for which the legal notice stage has occurred. So it gives a specific time frame. Another thing, through a legal notice, the sender notifies the addressee or the recipient about his intentions of undertaking legal proceedings against the latter. It works as a legal warning to the receiver to fulfill a certain condition if he does not wish to fight a court battle. Correct? So, for it's a basic thing. Legal notices, it's a pre-litigation thing, giving the other party a chance that this is going or this is getting out of the legal things which we had decided earlier, or the terms and conditions we admitted to. Now there are certain wrongs, or there is certain rectification which needs to be done, or you need to uh, stop from doing, or you need to refrain from doing something, or you are doing something wrong, you need to rectify that. This is a legal notice is a communication for sending those intimations to the other party. Now, when to send a legal notice? As I said broadly, there are two cases, one is criminal and other is civil. All formalities are addressed, because in criminal cases all formalities are addressed by state authorities except in check bounds. Legal notices are generally now sent in civil cases, such as what broadly it will cover is if there are certain property disputes, there is a loan default, somebody is a loan defaulter, to recover money from them. For money recovery, legal notices are sent by the banks or the person who has lent the money. Property disputes are there. Then comes the personal clashes. Now, what personal clashes mean? For example, in case of child custody, prenuptial agreement infringements, personal maintenance, divorce, conjugal rights, etc. They all come under personal clashes. In those cases, also, it's obligatory that a legal notice should be sent to the other party. so that before going into the court, if the things are understood by both the parties, they can settle it out of the court. Then comes customer complaints. Generally nowadays, customer complaints or consumer disputes and all. In those cases also, legal notices are sent to the manufacturers or the service providers. Then filing complaints against an employee or an employer, service disputes, service agreements, or there's something in culture, workplace. So to rectify those things, a cautious letter or a warning letter, they all are termed as a legal. Now comes, what is the importance of a legal notice draft? The significance of a legal notice format is most likely to assist an individual in resolving their concern about how to take a legal action to settle the issue. As I already told that the ultimate end result is that if the relief sought in legal notice is not provided by the addressee, or if addressee is not restraining from doing any such act which the sender thinks so is against the law, rule of law, then how a legal action to settle that issue arises is already communicated to the addressee. From the perspective of a litigator, a legal notice is a fresh start. A legal notice has four crucial components now. One is clearing intentions, then is explaining grievances, then is opposing parties' opportunity, then is quick reminder. This is, I'll deal it like this. When a legal notice is received, the receiver is given a clear indication of the sender's intention to file a lawsuit in order to resolve the case, to which the opposing party could respond before the statute of limitations expire, allowing the sender to avoid a legal suit. As I already said, if the receiver abides by whatever is requested in the legal notice or whatever is told in the legal notice, that these, as per the law, you are in such a such and such way, you are in a default, or in a particular thing that you are doing wrong, you are to refrain from this. If it agrees, then they can avoid a legal suit. Otherwise, they give a clear cut intention of a sender that now I am going to initiate a lawsuit against you. Then comes explaining grievances, which is a very important part of a legal notice. That you need to explain what exactly the grievance is. What led you to send this legal notice? You can send it by yourself, or if it's there are certain legal terminologies you are not able to cover each and every aspect, and you think for further clarity, you can seek advice of a practicing advocate who can, in a very detailed way or in legal terminology, also help you to garnish your legal notice. Then comes opposing parties opportunity. Now, opposing parties opportunity is also to be seen in this. That's why I said that there are time frames which are already provided in the legal notice, that whatever is to be done within 15 days or of 20 days from the receipt of this particular communication. So the recipient of a legal notice is given one last chance to settle the dispute amicably. Then it's a quick reminder. As I said, a legal notice serves as a subtle reminder to the receiver that this is the issue, you need to address it now. Now comes, what should be the effective content of a legal notice. At this point, I'll just explain you with a very simple example. Whenever you draft a legal notice or you are setting to draft a legal notice, one thing you should bear in mind is, as per my own personal experience, that one, it should not be a a long, never-ending tale of facts and material, because whomsoever you are addressing will not get what exactly you want to convey. So clarity should be there. There should be not. It should not be like using metaphors and using synonyms, so that it should be very clear. In terms, I'm saying it should be very clear and easily understandable by anyone who just picks up the legal notice and reads it. Second thing, legal notice from the very first initial opening para should be such that while reading that opening para, the reader, the addressee, the noticee whom you have addressed this notice comes directly to the knowledge that, okay, this is the issue which is being addressed in this legal notice. It should not be like you are writing list of dates, you are writing everything in this, and at the end of, say, couple of pages, then you say, okay, now this is the issue. This loses the interest also of a reader. And most of the time, we also, the sender also, there's a what there is a chance of superseding some important facts that they will just lose the sight. Now, coming back, contents of an effective legal notice. What should be very clear in this? The name, address, contact information of a person or the company sending the notice, because the communications will be carried on those particular credentials. As I said, a clear and concise description of the problem or the issue. Then comes, when you have came up with the concise description of the issue, then there should be a brief explanation that why and by what virtue this legal notice is being sent. It should not be that, okay, this is the issue and I am sending it to you. No, you should give them a legal research, what you have taken or what is the law prevailing at that particular time, which gives you the right to send this legal notice, which makes you empowered that, okay, this is the law, this is the breach you have done, this is the wrong you have done. Now, by virtue of that, I am entitled to serve upon you a legal notice. Then you wrote the description of the problem, you gave the explanation why you are sending this notice. What next? You should specifically clear what demand or relief or a request for a specific action needs to be taken by the addressee. Now, everything, all the above three things, they need to be done in a very closed-ended time frame, because if you leave it open, the addressee would say there was no time constraint. I was taking steps, but then it will be a never-ending process. They will be saying that it's a continuous process. I am taking steps. I am doing whatever I can do to rectify this. So you need to give a deadline to the recipient to take a specific action so that your demand or relief which you have sought in the legal notice is adhered to. Then, coming to the last thing in this, then, if the above is not done, if the aforesaid is not done, then a statement that a failure to take action may result in legal action against them. This should be a clear disclaimer in that. That if you don't do or if you don't adhere to this thing, then the failure may lead to a legal battle then. So, as I said, this all the information needs to be presented in a very clear and concise manner. It should be easy to understand, and I say that we should avoid and try to avoid using complex terms, complex legal terms. We should just simpliciter, make it so easy that a common person who reads the notice gets to know what whatever you want to convey in that legal notice, be it facts, be it law, be it the reliefs you have sought, or be it the disclaimer that if you don't do this or if you fail to adhere to the above said, then what next steps are going to be taken against you. That is the legal action. In all, the moment a person picks up a legal notice, the first opening title should be the subject. That what are you addressing to? So there are certain tips. It can vary from person to person or a person's how ability or skills to write a draft a notice. If a legal notice is sent through a legal advisor, then it becomes mandatory that this legal notice should be on a letterhead of that legal advisor. The language, as I said, should be easy to understand. It may be in any language. Title should be clear and loud. Party dispute pertains to such and such thing. For example, recovery of money, check bouncing, child custody. The title should be clear. We should avoid usage of abbreviations while addressing the matter. We should not use metaphors. Simpliciter that such and such date you took money from me, such and such date you promised to pay it back as per this agreement or as per this particular assurance from you. Now the time has come, you repay me, but you still fail to repay me. Now, all those things. This should be very clear because the words or the terms used should not be free to say dual interpretations. I shall, I will. Like those ambiguities should not be there. So that if it gives a dual interpretation at that particular time, it can be interpreted both ways in your favor or against you. So avoid words having double or doubtful meanings or even inherent ambiguity and difficulty in interpretation. What I wanted to say is avoid using those words. Be very specific that as per this contract, now you fail to repay, so this legal notice. Or as per this assurance, your check has bounced, so you need to repay within this and this, so this legal notice. So that it's specific. Other party is not given a chance to interpret it in their favor or as per their convenience. The body of the legal notice should be short and to the point. Avoid explanations. What you just need to have the gist of the issue, the law, the relief, the disclaimer that this failure would lead to this, and the time constraint. It is preferable to give the addressee a time frame of say 1 or 2 weeks to negotiate in a legal notice from the date of receipt. Otherwise, what the addressee would say, he'll say you initiated a legal notice against me, you issued a legal notice against me. I was not given any time, so I could not place my defense or I could not place my case or I could not place my side of explanation to you. So the for a effective communication, you need to necessarily keep a time frame of 1 or 2 weeks. If second thing, you need to show your willingness also that if you will say do this or I'll be compelled to initiate a legal thing. This shows that you are willing. If you are doing this, if you are giving me my relief, if you give me whatever I requested in this, then I may not be compelled. So I am willing to settle it outside the court also. So it shows our consent. So the draft should show consent. It should not be very adamantly said. So this is the issue. I am not going to discuss it further, and I am going to then it's okay, then go for a legal suit, lawsuit. Then the relevance of legal notice loses its essence. Next thing, the damages should be specifically and in a very precise manner set out in the legal notice. Whatever is the sender's demands and requirements should be set out in a very precise manner. The other party, the addressee, we should offer them alternatives to the litigation. That, okay, this is the issue. We may sit over a table before an arbitrator, or we may proceed mediation, or we can go for a conciliation session. So all those alternatives also need to be given. And the most important thing is service. Now it comes service of a legal notice. So it's better, it's always better, it's always good that a legal notice must be sent to the addressee through some registered postal services so that we can keep a tracking report also. And in the long run, the other party, the addressee, does not have any opportunity to say that I did not receive the legal notice and I was unaware about the initiation of legal notice. So I could not adhere, I could not take remedial steps, and it becomes a very important piece of evidence in further trial that you have done your due diligence and you have already sent them the legal notice through a registered postal service. Nowadays, even legal note, it can be sent through emails since it says signed, but the postal aspect also is a very documentary, good documentary evidence. Now comes what is the procedure for issuing a legal notice in India. The procedure has been dealt with under Section 80 of Civil Procedure Code 1908. It specifically says if you need to send legal notice to Union of India or state government, then whom it should be addressed, and in case it's addressed to railways, whom it should be addressed. And as I said, legal notices are only sent in civil cases, and in criminal, there's an exception. That exception is negotiable instrument right, check bouncing cases, because in criminal cases, government brings action against the wrongdoers by filing an FIR, and it's an offense against the state, and state provides protection to the victims. So legal notice is not mandatory in there. Now, as I said in Section 80, they have specifically said if the suit is filed against central government and state government, then the secretary of the government or collector of the district is to be addressed. If it's railway, then general manager. And if it's against a public officer, then the notice is to be addressed in his name or delivered at his address, office address. The notice must be in writing and must contain, I'm again repeating, it may be a repetition, but this is an important thing, that it should contain the following informations, because lack of any information would just not furnish the use of legal notice. The name and address of the person or entity issuing the notice, that is must. Against whom it's being issued, that is also to be clearly stated. Clear statement of rights that have been violated, that this is the state right which you have violated, and that's why this legal notice stands against you. Demand for relief, such as request for damages or an injunction, or by injunction that you are being refrained to do so, or in like in civil cases, like in property disputes, that if somebody is throwing someone out from the premises, so to refrain from doing so, so injunctions need to be required over there that you are refrain from doing such and such thing. It should be signed by the authority, by the person or entity who is issuing it, the legal notice. If it's through a legal advisor, then the advocate, or if it's by anyone, then signatures are must on each and every page at the end. Then delivery of legal notice is important, that the sender needs to take all the steps, all the necessary steps, so that the notice is delivered to the specific person, then time to response. So this is the broader framework of a legal notice. It depends on situation to situation, and the basic about drafting a legal notice is that how well you address your issue, how well you raise your demands, how well you raise your relief, claim your relief, and how well you pave a path for your future trial. If you miss something in your legal notice, it can have a cascading effect on the trial of the case in the long run. So, legal notice is a very important document for an amicable settlement also, and if it fails to do so, then during the trial, this legal notice and the facts raised in these legal notices, they play a very pivot role in decision or deciding the particular issue. So I'll take a leave, not stretch it further. I hope to whatever I have my personal experience, I was able to address it to you and make you understand in a very simpliciter way. All the very best. Thank you.